Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Thank you. Please be seated. First case on our docket this morning is styled Maestas v. People. We've got it set for an hour. Both counsel look like you're arranged. So let's go ahead and get started. Counsel or petitioner, please begin your argument.
Good morning. May it please the court, my name is Sarah Kellogg, and I represent Mr. Maestas in this case. I plan to reserve a little of my time for rebuttal, and I'll keep track of that. A court, any court, cannot uphold a conviction if the state did not prove all the elements of an offense beyond a reasonable doubt. If the conviction is based on insufficient evidence, it cannot be affirmed. In Colorado, we have our own criminal procedure rules adopted by this court. Rule 29 specifically addresses this issue, and so it applies in place of other general rules. In this case, applying Rule 29, this court could adopt a narrow rule that general motions for judgment of acquittal preserve a sufficiency claim on appeal, and that would resolve the issues in this case. Or this court could adopt a broader rule that whether or not a motion for judgment of acquittal was made, a court on appeal reviews a sufficiency claim under the general sufficiency of the evidence standard. Rule 29 allows for either approach. And that's because it's a unique rule which both requires a defendant to make a motion, or allows a defendant to make a motion for judgment of acquittal, and requires a trial court on its own motion to enter a judgment of acquittal if the evidence is insufficient. This rule is also different from the federal rule in a critical way. The federal rule says a defendant must make a motion for judgment of acquittal if the evidence is insufficient, but then simply says the court may on its own consider whether the evidence is insufficient. And our language in Colorado says the court shall, on its own motion, enter a judgment of acquittal. This approach in Colorado also makes sense because sufficiency of the evidence is a unique claim. When evidence is insufficient, a court cannot and should not affirm a conviction because that means an innocent person will have been convicted of a crime. And so the rules provide for several avenues for a court to ensure that fundamental fairness applies and innocent people are not convicted of crimes that they did not commit. And innocent in this context does not mean morally blameless, as Jackson v. Virginia noted. The United States Supreme Court in Jackson v. Virginia explained that a person does not need to be morally blameless to have the benefit of the beyond a reasonable doubt standard, and said, under our system of criminal justice, even a thief is entitled to complain that he has been unconstitutionally convicted and imprisoned as a burglar. And so applying Rule 29 in this case, I think, answers the question for the court on appeal.
Ms. Kellogg, while you're paused, let me ask you, could you address Hagos, cases like that say, all other issues are reviewed for plain error when you get to that?
Yes, and I think that's true for trial errors that are forfeited or not objected to in the trial court. And Rule 52B, the plain error rule, does apply. Sufficiency is different. One, because of Rule 29. Rule 29 applies instead of the plain error rule. And that's partly because of the very specific language that we have in our Rule 29. And I think Hagos just simply wasn't addressing a sufficiency claim.
But this is not a typical sufficiency claim, right? Because you have to interpret a statute first.
You do have to interpret a statute.
And that's an interpretation that was not advanced before the trial court, correct?
The argument was not specifically made, that's right.
Okay, so it's being advanced for the first time on appeal. And so this is not the typical type of challenge to the sufficiency of the evidence that we get.
Well, I would argue that it is fairly typical. I mean, it happens with some frequency that at some point along the way, a counsel or someone might read the statute. And here, the argument that was advanced in the Court of Appeals was simply a plain reading of the statutory language, supported subsequently by the Court of Appeals opinion in Poindexter. But it is a sufficiency of the evidence claim. It's no more than that. It's what this court or any appellate court always does. Read a statute, review the record, and determine whether or not the evidence is substantial and sufficient to meet those elements.
I've seen, I think Judge Webb has said this, I think Judge Bernard has said this, I think maybe Judge Jones has said it as well. The proposition that whether we apply plain error or not will only make a difference in a very narrow category of cases where you would have the requirement to interpret a statute before you get to sufficiency. That interpretation was not advanced at the trial court level. It's being advanced for the first time on appeal, and it's not obvious. It wasn't obvious. It wouldn't have been obvious to the trial court. Do you agree with that?
No, not at all. One, even in a narrow group of cases, you can't violate someone's due process rights to be convicted on less than sufficient evidence. So even if it only would change the outcome or create a problem in some cases, those cases are a problem, like, for example, what the Court of Appeals did here.
I guess my question
Yeah.
was more, do you agree with the proposition that those are the only cases where this will make a difference? Our determination whether plain error applies or not would make a difference.
I guess I do agree with that, yeah, but I think that difference is a problem, right, because it would violate due process, as it did here.
Can I ask you, other than Localo and Maestas, are you aware of any case anywhere that created this rule that said we could skip over whether there was error and decide whether it was obvious?
I think sometimes federal courts do. I don't know for sufficiency, in the sufficiency context.
That's what I'm talking about.
Right, yeah, no, I'm not aware. And there might be one out there, but I don't know it.
Could I ask you?
Yes.
That's a pretty broad sort of rule that you're asking for. Do you think, would it mean that the defendant, no matter what his behavior, couldn't foreclose the possibility of him demanding that proof beyond a reasonable doubt on all the elements of the crime be attained?
Yes.
So even invited error, even if a defendant were to ask for a specific instruction articulating elements, and then later he should be allowed, under your theory, to argue, no, those weren't really the elements, and given what the elements really are, you didn't have sufficient evidence.
Yes, and it's not my theory, it's the requirement of proof beyond a reasonable doubt. And so at any time when the elements were not proven beyond a reasonable doubt, conviction cannot be affirmed, that someone can't stand convicted. I think the only way that there could be invited error or something like that is if you plead guilty. And then you're waiving your right to have the state prove the elements of the offense beyond a reasonable doubt. In some instance where maybe, I'm sorry.
No, so I'm not sure I understand. So in that context, you would be waiving your right?
In a guilty plea, you are waiving your right to have a jury trial and to have the state prove the elements beyond a reasonable doubt.
So is it only like a knowing, voluntary, and intelligent waiver, like a constitutional waiver of a trial right that would satisfy the requirement from your point of view, rather than other foreclosures that we typically deal with? Estoppel, forfeiture, you're saying those would not work?
I haven't thought specifically on those, but I don't think that they would, because a state always has the burden to prove a conviction beyond a reasonable doubt, and if it has not done so, then the conviction cannot stand. In the guilty plea context, the defendant is waiving that. In, for example, a lesser included or non-included offense context, probably much of the time there would be substantial and sufficient evidence taken in the light most favorable to the prosecution if, for example, defense counsel requested a lesser offense instruction or something like
But
that.
since you mentioned that, just a couple of years back, in the Montoya case, didn't we say, or are you distinguishing that somehow, that the defendant, having asked for a lesser offense instruction, could not raise on appeal that there was insufficient evidence for that because he had, under whatever theory, invited estoppel, forfeited that right?
I don't remember Montoya specifically, but given that circumstance, I think that if a defendant is requesting a lesser included, there must be some evidence to support it. The standards are different. The state always has to prove the elements beyond a reasonable doubt to properly uphold a conviction, for a court to properly uphold a conviction. But I think that there wouldn't necessarily be an estoppel, although I'm not addressing Montoya specifically or asking this court to overturn it. I don't think this court even needs to reach this issue. It can simply apply Rule 29 and find that, it's sort of inherently preserved because the issue is always presented to the trial court, because the trial court shall, on its own motion, enter judgment of acquittal if the evidence is insufficient.
I appreciate your argument on 29,
yeah.
but I took it you were arguing more broadly that as a matter of due process, this is required. Even if we didn't have the rule, we simply could not have a conviction based on insufficient evidence.
I think that's true from Winship and Jackson v. Virginia. A court cannot affirm a conviction on insufficient evidence. My due process argument was more about the manner in which a court may apply plain error review, whether if this court does not follow the Rule 29 argument and instead would like to apply plain error to a sufficiency context, which it has never done, and in Morse v. People in 1969 it did not do. But were it to do that, and were it to apply plain error in the way that the Court of Appeals below has applied it in some cases, and in this case specifically, that would violate due process. And this court, were it to apply plain error review, does not need to do so in a way that violates due process. It can interpret a statute on the plain language. Plain language of a statute presents that, makes obvious to everyone what the law is. If the statute is somehow not clear about what the law is, I don't know why the defendant has notice of what conduct is prohibited and is criminally liable. I think that's one problem with the way in which the Court of Appeals has applied it. Here, the Court of Appeals also said the law was unsettled and Poindexter hadn't come out, so how would the trial court have known about that? Well, it's common language in our Court of Appeals that an error, to be obvious under the plain error standard, has to be so obvious that a trial judge should be able to avoid it without the benefit of an objection. That's frequently used language. And if you trace that back, it goes back to a Court of Appeals case from 2005, People v. O'Connell. And People v. O'Connell was quoting a Ninth Circuit case, U.S. v. Turman. Turman was explicitly abrogated by the U.S. Supreme Court in Henderson. And so Colorado now, in applying the standard that it had to be so clear-cut and so obvious to the trial court that they could have acted without the benefit of objection, is applying language that the U.S. Supreme Court has explicitly abrogated. And again, in my view, that's not really an issue this court needs to grapple with in this case. But were this court to apply plain error and apply it in the way that the Court of Appeals applied it, it would have to find that the language of the statute was ambiguous or unclear, which was never argued. This argument was always just based on the language of the charged offense that the prosecutor charged Mr. Maestas with, and how it was submitted to the jury. This court would have to find that the law was somehow unsettled, and then find that a court cannot clarify that law on appeal, but can just ignore a confusion in the law and affirm a conviction even when someone maybe didn't commit the offense, which just violates fundamental notions of due process. That's where we get to the due process part of it.
In this case, Henderson had been decided by the time this case came up on appeal. I'm sorry, Poindexter had been decided by the time this case came up on appeal. Under the Henderson rule, the Court of Appeals would be looking at that precedent at the time of appeal. This court hasn't really adopted the Henderson rule, but is that another route that you're proffering here? That this court should take the Henderson approach and look at the plainness of the error at the time of review as opposed to the trial?
This court certainly could, were it to apply plain error to a sufficiency of the evidence case. It could, and it doesn't need to necessarily adopt the wholesale federal interpretation, which in fact would not make sense in this case because our rules are different than the federal rules. For example, our Rule 29 is different from the federal Rule 29. So this case is a poor vehicle to sort of use a federal approach, but the context of Henderson makes sense here for sure. And certainly having the law clarified on appeal, we all know what it is. Now, how can a court of appeals or an appellate court of some kind affirm a conviction when the person didn't commit the offense? It simply can't do that.
Ms. Kellogg, what rule are you asking us to adopt? What do you want our holding to be?
I think to me the most sensible, reasonable holding is that CRIMP 29 in Colorado is a unique rule that serves to essentially preserve sufficiency issues, both because the defendant can make the motion for judgment of acquittal, but also the court on its own motion must make it. And therefore, talking about the standard of review for unpreserved claims doesn't make sense in the sufficiency of the evidence context. So simply articulating Rule 29.
Okay.
Can I try to, I'm sorry.
No, go ahead.
Can I just try to pin you down on that? Because you offered sort of two different approaches at the outset. You were saying first that a general motion for acquittal blanket preserves any sufficiency claim, even if it morphs somewhat on appeal. Alternatively, you said under Rule 29, no motion is necessary because it's inherently preserved. So which of those two options are you wanting?
I'm fine with either one.
Okay, I think that's where Justice Boatwright may have been headed, so I just wanted to pin you down.
Yeah, I mean, not that I'm not trying to be pinned down, but if,
Can I step in just a tiny bit and just say, not so much for this case, but broadly, what do you think our holding could be so that the appellate courts know?
Yeah. Well, I mean, I'm concerned about this case and Mr. Maestas' burglary conviction.
Sure, I understand.
Right? He's my client.
Right.
And there was a general motion for judgment of acquittal in this case. So this court could adopt a very narrow approach. However, I do see the benefit in taking a broader approach that Rule 29 applies, and therefore a general motion for judgment of acquittal is not necessary to preserve it on appeal. That sufficiency claims are reviewed under the general sufficiency of the evidence standard, articulated many times in this court, in Bennett, Kogan, Dempsey, Clark, and that's the standard a court uses to review sufficiency claims, regardless of whether a motion for judgment of acquittal was made.
Do you see, I mean, obviously the purpose of making an objection is to promote efficiency and correct things. Do you see any unintended consequences if we say there doesn't need to be a motion? Do you see potential inefficiencies?
Not that I see, because those policy reasons don't apply in the sufficiency of the evidence context. This is a very unique claim where we're talking about the state's entire burden. The whole purpose of a trial is for the prosecution to prove the elements of the offense beyond a reasonable doubt. And a defense counsel has no motivation to lie in the weeds, as it were, and not raise this issue, because it would result in their client potentially being convicted and going to prison, sitting in prison for years, waiting to potentially win the issue on appeal. I mean, that would be essentially malpractice, I believe, or contrary to the rules of professional conduct and zealous advocacy on behalf of a client. I think those policy considerations don't apply in this context. And then also Rule 29, the court has to do it on its own motion. So there's no benefit to counsel. And then also, if there were a benefit to counsel, for example, if they thought, haha, the state forgot this element or something, Rule 29 actually allows for sandbagging because it allows a motion for judgment of acquittal to be made up to 14 days after the verdict is entered, whether or not it was made at the time of trial. It's in there. So if you did have a defense lawyer who somehow was very more clever than everybody else in the room and had this idea, they could, under the rule that this court has adopted, they could just wait until after the verdict.
Thank you.
Until Lacala, wasn't the law quite settled, at least in the Court of Appeals, that no motion was necessary?
I think that was clear.
And so we have a lengthy history of the world not falling apart.
We do. And again, the general sufficiency of the evidence standard is perfectly adequate in every case. It's not an easy burden for the defense to meet to prove that the state failed to meet its burden.
And am I remembering correct that in the civil side, you do not have to make a motion for judgment notwithstanding the verdict?
I believe that's correct.
I'll ask one other question, thinking about the breadth of this. So would you be saying then that if someone is convicted of a crime that turns out to be unconstitutional, there wasn't sufficient evidence of a crime that exists, that could exist, and so would that always be raisable without regard to objection down below as to the constitutionality of the statute?
If they're arguing that the statute is unconstitutional, so what they were convicted of simply was not a crime.
Right. So
for
if you
example.
failed to challenge the constitutionality of a definition of a crime, you're convicted of it, then would our prior statements about not being able to raise that on appeal, the constitutionality, would they be gone under your argument? Would you always be allowed to raise the constitutionality?
Well, I think the prior statements have been drawn into question. Cagle was drawn into question, and Reina Barca noted that it was dicta, that you can't raise the constitutionality of a statute for the first time on appeal. And to the extent that someone is convicted based on insufficient evidence, whether, in some instances, maybe it's hard for me to think of an example where the evidence maybe would have been sufficient, but if that's truly not a crime, I don't see how a court has the authority to affirm a conviction.
And let me ask you one other, I'll try not to eat up all your reservation here. With regard to the effect of finding a reversal for insufficient evidence, even if that now, as you're arguing, is because the statute defined the crime differently and nobody knew that, or constitutionality. Nevertheless, because of Burke's, the insufficiency has always been in a kind of different class by itself because the defendant can't be retried.
Right.
So would you be arguing that if, because of the statute being unconstitutional, there was insufficient evidence to convict the defendant of a crime, or because of the statute being construed differently on appeal, that there was insufficient evidence, that those would result in a complete bar to re-prosecution for that conduct?
I think it would depend on the circumstances and exactly how that played out. If it was an insufficient issue, essentially, then yes, Burke's applies. I know that there are some federal cases that my opposing counsel cited where, for example, the statute was construed in such a way that an additional element was now required, but that statute was not found to be wholesale unconstitutional, and there was sufficient evidence as to it initially. That's the opposite of Burke's, of a case where the evidence was insufficient initially. So I think it would somewhat depend on what was the unconstitutionality and how that all kind of came about in the circumstances.
Thank you.
So, Ms. Kellogg, you mentioned a moment ago, I think, that defense counsel would have every incentive at the trial court level to raise whatever arguments are available. If that's the case, why isn't it fair to require that an argument such as the one being advanced here be raised first at the trial court level so that the trial court judge can have an opportunity to address it?
I mean, that might always be an ideal scenario, but certainly things are going to be missed, and that happens in trial court. It's not fair because if ultimately the court reads the statute, the plain language of the statute, and then reviews the record, as courts do under the general sufficiency standard, and finds the evidence is insufficient, then it can't affirm the conviction. So, or doing so would violate the defendant's fundamental fairness rights to proof beyond a reasonable doubt. Also, Rule 29 applies. The court, on its own motion, has to raise it. So, the court is equally deemed to know the law. Defense counsel is not necessarily the only one in the courtroom who should know the law. And then finally, the prosecutor is the one who decided to bring the charges and what charges to bring. And, they have vast power in determining how to charge someone with a crime. And they're obviously aware of their duty to prove each element of that offense beyond a reasonable doubt. So it's all there before the court. Nothing is new or different. It's not like trial errors, reviewed for plain error usually. It's sufficiency is different.
Am I remembering correctly, there's a body of law in the kind of the Teague versus Lane world and retroactivity world that says when the Supreme Court decides what a statute means, it's deemed to always have meant that. Am I remembering that body of law correctly?
I think that's generally right. That's right. It's just explaining what the law always was.
All right. So here, I guess I'm picking up on Justice Simore's question. I suppose, and here an argument, it's how is that fair to the trial judge when somebody down the road decides what the law meant? But the law, if I understand it, the law is that it's always deemed to have meant that. And so the defendant gets the benefit of that. Is that right?
That's right. That's right. And that's just our constitutional approach in this country. The constitutional rights, the Fifth Amendment, Sixth Amendment apply to the defendant and serve to protect from, something being convicted of a crime on less than proof beyond a reasonable doubt. If there are no further questions, I'll reserve my time. Thank you.
May it please the court, my name is Brock Swanson, attorney registration number 39116, and I represent the people of the state of Colorado in this matter. Our system tolerates letting those who have committed a crime avoid accountability for their actions when it is necessary to ensure that the innocent are not wrongly convicted. But when those who have committed a crime go free, it is an injustice. Applying plain error to unpreserved sufficiency claims will not deprive any defendant of an appropriate forum to show that his or her conviction is unjust. But carving out an exception to plain error for sufficiency claims and vacating convictions in cases where the prosecution never had notice that it was required to prove an element will result in unjust outcomes.
What is the prosecution's interest in having someone who was convicted without evidence beyond a reasonable doubt sit in prison?
I could say this. The people's interest is in justice. The people's interest is in that one full and fair opportunity for the defendant's guilt to be decided. So the people do not have an interest in someone who has not committed a crime being punished for that crime.
But isn't that the effect? Isn't that the effect of Locallo? We skip over, and in this case, where the majority said we can, whether or not the evidence was sufficient, we could decide if it was obvious. On that theory, someone who was convicted without evidence beyond a reasonable doubt can sit in prison. Where is the justice in that?
And I think I'd answer that by saying that ultimately in this case, whether to apply plain error to sufficiency claims is not a question about whether those who have not committed a crime should be punished. Everyone agrees they should not be. The question is, what is the appropriate forum to address those claims when the lack of notice in the trial court means that the record on direct appeal is inadequate to determine what would be a just result? If a defendant loses a sufficiency claim on direct appeal because any error was not plain at the time of trial, that is not the end of the matter. The defendant retains the ability to claim his innocence in the trial court under a number of different procedures and theories, where the court can then decide, based on a fully developed record, what would be the just resolution of the defendant's claim.
Walk us through that. I assume you're talking about 35C.
Sure, I don't know that it's my place necessarily to opine on what course of action the defendant in this case or these other cases to take, but I think at minimum, if the defendant can show in a Crim P35C or a habeas proceeding that the prosecution did not and could not present any evidence that he committed an offense, that claim would be cognizable and entitle him to relief.
Here's my concern, and I'm just pushing on you. I know you know that, Mr. Swanson. Let's say the 35C argument is that the conviction was unconstitutional. I fear the argument will be it was raised and resolved in the prior appeal or could have been raised, so it's barred. If it's an ineffective assistance claim, the argument will be the law changed, therefore counsel was not deficient, there was no deficient conduct. And so now 3 years down the road, we say you're out of luck, and I'm still having trouble seeing how there's justice in that, even if the defendant wins.
I agree, but I don't think that those concerns will come to pass. I don't think that the claim that you would be making in the post-conviction claim would be the same claim that you're presenting here, because it includes the component that they could not present that evidence, that there is an additional factual development that will be necessary in order to present that claim. And that's the component, that is the people's interest here, is that there are facts that we don't know because there was no notice to the parties in the trial court that this was an issue that was going to be relevant. And so we don't know what the facts are. And so the people's interest is that this be decided in a forum where they will be able to develop those facts and then determine what is the appropriate and just outcome for the case. And so applying plain error is a way that gets there. And it's the way that what these people are asking the court to do in this case is just to apply the criminal rules of procedure as they are written and as they have been consistently interpreted by this court, because they appropriately balance the interests and incentives.
Can I ask you one more question,
Sure,
Mr.
go ahead.
Swanson? It's the same question I asked Ms. Kellogg. Are you aware of any cases besides Locallo and this one where a court in a sufficiency context said you can skip over error and decide not obvious and affirm a conviction?
Sure. In my brief, I cited a couple. There's United States versus McCoy, which is out of the Fifth Circuit, which is 702 F3rd 806, and then United States versus Ramos Arenas, which is within the 10th Circuit, 596 F3rd 783, and those are both in my brief. And those were both cases where the court just declined to resolve the ultimate legal issue, but denied the claim because the error was not obvious. And I'd also note that in other contexts outside of sufficiency in Colorado, that is frequently done where the courts will decline to address the legal error because it is not obvious. For example, in People versus Scott, the court did not resolve the legal error and denied the claim because it was not obvious at the time of trial.
And so I'm going to lie to you, having said I was going to ask you one more. I'll ask you one more after that.
Sure.
On the federal cases, in the federal courts, of course, there's the fourth prong of plain error. And as Ms. Kellogg said, you also have to preserve a motion for judgment of acquittal in federal court. Did these cases you relied on pick up on those distinctions, or do those things distinguish the federal cases?
Those cases, I'm not sure about on the preservation requirement. They definitely relied on the fact that it had to be preserved, and our argument is that they have to be preserved here as well in Colorado. But they did decide the case on the plain prong, not on the fourth prong of plain error.
Right, thank you.
And in those cases, was the unpreserved sufficiency claim a question of statutory interpretation?
That's correct.
Okay.
There are cases like this.
Mr. Swanson, can I, sorry. You said that there are situations where there'll need to be further factual development, and that's why these need to be held at the trial court. So kind of the same question I asked Ms. Kellogg, and I guess specifically, can you give me an example of where we would have undeveloped information?
So, sure. I think let's see. This is a case where that is the case. We have here a situation where the defendant is arguing that there's this showing that was required that was not known to be relevant issue at the time of trial. And it's about the nature of the defendant's actions when he was contacted inside of this building where he was charged with burglary for obstructing a police officer. And we don't have that testimony about what happened inside there. The officer who actually contacted him did not testify because they didn't know that that was going to be a relevant issue. The instructions in this case were just categorically said if he had the intent to obstruct a police officer, then that was sufficient to establish the burglary. But the defendant is arguing here that there needed to be some further showing of a particular kind of obstruction of a police officer in order for it to be a qualifying predicate offense.
But help me how there would be further development, because a judgment of acquittal is going to happen after the prosecution rests.
Okay, so if this had been raised at the time, properly raised at the time of trial, the trial court could then, if the prosecution heard that argument, and they could have said, oh, we could have evidence that would resolve that issue, and then ask the court to reopen the case. And the court could then reopen the case and permit them to present that evidence. And then we would have that factual development at that time.
Aren't we encouraging then, as Ms. Kellogg said, to wait for the motion till the verdict's been rendered then?
So, and that ties in.
That to me,
sorry.
encourages inefficiency.
That ties in with the remedy argument that I have also made based on these federal cases. Our position would be that if the defendant waits until after the case has been submitted to the jury, that then that implicates this remedy argument that he would only be entitled to a new trial rather than an acquittal if it's based on a requirement that they did not have notice about. The prosecution didn't have notice about. And also, there would then at that time be an opportunity for the prosecution to present their evidence about whether they could or could not have proven that, to say whether we even need to have a new trial or whether there was even an actual issue that would have been disputed about that. Does that make sense?
Well, I understand your argument. I'm not
Right.
sure it makes sense that they would get a new trial because the prosecution didn't present all of their evidence and they pointed that out. I mean,
Well, they
seems
would
like-
be pointing it out after the fact, after the trial had already occurred. They would be arguing that there's another new,
I don't
Just to
think
clarify.
there's any requirement that they stand up and go, Judge, before they rest, I'd like them to present evidence on this. I mean, it feels like, I'm not trying to be glib about it.
Yeah, no. And I think this is responsive to what you're saying, is that, again, I'm only talking about this very narrow category of cases where the defendant is arguing that there is some additional requirement that's not obvious, that's not already plain. If this is some requirement that just derives from the plain language of the statute, then the prosecution's on notice of it and they have to fulfill that duty. This is a very, the impact of applying plain error is going to have a very little effect in the vast majority of cases because it only applies to this narrow category of claims. And I'd point out, we talked a little bit about the pre-Lacayo cases that we've had in this Court of Appeals for a long time. And I'd note that the outcome was not affected by the determination of whether to apply plain error or not in any of those cases. All of those cases either affirmed because there was sufficient of evidence or they reversed because there was a failure to prove what would have been an obvious requirement. Lacayo is really the first case where this has been at issue and could be determinative of it. So I don't think that the fact that there was all this case law out there for a long time, and there was case law both ways, there was case law in the Court of Appeals applying plain error and not applying plain error, that is really too relevant because it just hadn't developed to the point, or we hadn't gotten to the point where we needed to, this court needed to address the issue until we've got this case where they're arguing for a new requirement to be added, and then that the prosecution never had any notice that it was required to prove in the trial court.
So let me ask, same question I asked Ms. Kellogg. What do you want our holding to be then? Because it feels like you're saying this is an exception. So what do you want our holding to be?
Our holding is that you should not make an exception to the plain error rule for sufficiency of the evidence. That the rules in People versus Miller, this court held that unpreserved constitutional errors are reviewed for plain error. And since then, this court has unhesitatingly applied that standard plain error to claims that are essentially analytically indistinguishable from the claim in this case. For example, in Davis, this court unanimously applied plain error to the defendant's claim that one of his convictions must be vacated because there was insufficient evidence to support it as a separate conviction. In Scott, this court applied plain error to a defendant's claim that one of his convictions must be vacated based on statutory interpretation. And this court held that even if he's right, he was not entitled to relief on direct appeal because any error was not obvious at the time of trial. So we're just arguing not to carve out an exception from these general rules, which carefully balance all of the interests at stake in preserving and addressing unjust outcomes, and just apply that as you have in any other case to this case. So it's about not carving out an exception for sufficiency of the evidence.
But in a typical sufficiency of the evidence case or challenge, you would have us just look at the evidence and determine whether it's sufficient when viewed in the light most favorable to the people, so that wouldn't change, right?
That's right. That's right. We're not arguing that it would change the actual underlying standard. I know there's some disagreement or discussion about that in the federal cases, but we are not asking that they would actually change the underlying legal standard for whether there is error. Just that there would be these additional requirements, and that they would not be applicable in the vast majority of cases in any way that would change the outcome. But that when the plainness is a bar, that there's a good reasons for that, and that's why it should be applied.
Mr. Swanson, can you address Henderson and whether we
Sure.
ever apply that standard?
Sure. So this court has already held post-Henderson in cases that the time of trial interpretation of the plain error requirement should apply. And there's nothing in Henderson that presents any compelling reason to depart from that rule. The majority in Henderson indicated that its interpretation was primarily motivated by its concerns about different treatment for defendants based on circuit splits. And that is simply not a concern in Colorado because we do not have separate circuits and thus aren't going to be in that situation. And it justified its interpretation primarily by relying on its prior decision in Johnson, which had held that an error is plain if it was clearly settled against the defendant at the time of trial, but now is clearly settled in favor of the defendant at the time of appeal. But this court has not endorsed the Johnson rule, nor need it, because our rules, unlike the federal rules, already have a separate and, in my opinion, superior procedural mechanism for addressing that situation where the law has changed, and that's in Crimpy 15SC1, which permits defendants to immediately file a motion and obtain relief in the trial court if the law changes while the defendant is on appeal. So we don't need to adopt Johnson or adopt Henderson in order to find that situation. I think also, then this is a point that's made by the dissent in Henderson, but it's important to note what that Henderson does to the plain error requirement. By untethering it from the time of trial, it's really leading to more arbitrary results, because it would mean that two co-defendants who are tried together could raise the same unpreserved claim on appeal and achieve different results based solely on how long it happens to take for the appeal to be resolved. One of them gets their appeal resolved earlier, and then the other gets his appeal resolved later after subsequent cases come out and made the error plain. And that is more arbitrary, I think, than deciding to having them a rule that would treat them the same.
Wouldn't we treat them the same if we assume that the law that the court decides ultimately the statute meant always applied that way? Both defendants get the benefit of that.
I mean, if the defendant, the co-defendant had his case already resolved before that law came out, then he would have lost and he would be presumably out of time.
But if he's entitled to raise it for the first time appeal, he may get it resolved at that point. I mean, I guess it's the distinction between the 35C, after and we've got a case today that raises this issue. I mean, I guess I'm not understanding the distinction you're trying to make.
So
It would seem either one, defendant number one, who, he loses, then the law changes, then his only option is to raise it on a 35C, and it sounds to me you'd say he gets the benefit of that. And the defendant who gets to raise it for the first time at appeal gets to make the argument and presumably would get the benefit of the statutory interpretation.
I mean, I guess I'm speaking beyond just the sufficiency context here. So there are certainly issues where the law can change after your conviction becomes final on direct appeal, and then you're not entitled to have that law come back on in a post-conviction motion apply to your case because of interests and finality.
That was the issue. That was the issue that I asked Ms. Kellogg about, and maybe you can help if you think the law is different. I think there's a body of case law that says when the Supreme Court decides what a statute meant, it's deemed to always have meant that. Am I incorrect about that?
I mean, it just depends on the legal issue. The specific thing you're talking about there about like an interpretation of a statute, but there are other different things where some of them go back and some of them don't. Some of them depend on whether your conviction has been final. The change happened while it was final, and some before it became final on direct appeal, and some don't.
And maybe I'm not being clear. The distinction I'm making is the Teague line of cases that talk about new rules of constitutional criminal procedure versus a substantive reinterpretation of the law or new interpretation of the law. Frankly, the case I'm thinking of was called United States versus Ratzliff, a United States Supreme Court case, and I only know it because I dealt with that issue in the 10th Circuit. And the rule was the later interpretation applies to someone who raised it before.
And the issue is that I think addressing your concern is that if you're adopting the Henderson framework, you're adopting it for all claims. And so it needs to contemplate the effect that it will have on all claims, not just those that address like the sufficiency claim that would be here.
All right, I understand your point. Thank you.
Sure.
So, Mr. Swanson, if we, just following up on Justice Gabriel's questions, if we adopted Henderson, what happens here? What's the result?
The result here would be that the error would be plain under Poindexter if I made an argument that Poindexter, there is sufficient evidence even under Poindexter, but because that case had been decided at the time of the appeal, you'd be able to apply that law to this case, and you wouldn't deny it on the basis of the plain. We would still argue that plain error applies. It just would no longer the plain requirement would no longer be the determining factor. That's what the Court of Appeals relied on in denying the claim.
While there's silence, Mr. Swanson, could you address Rule 29? Ms. Kellogg makes an argument that Rule 29 is distinct from Rule 52 because it does say a trial court shall enter a judgment of acquittal if the evidence was insufficient, and that makes this different than a usual plain error circumstance. Could you address that?
Yeah, I have a couple comments I'd like to make. The first is that I'm not sure that I agree with the reading of the statute as saying that it says of its own motion shall do this, but I don't think it is requiring the court to always make its own motion or consider it sua sponte. More generally, I would say that I don't think that the rule doesn't address preservation and the appropriate standard for reviewing this on appeal. I mean, if anything, by its plain terms, it indicates that the court lacks authority to consider a claim that there is insufficient evidence 14 days after the verdict. If you're just going to read it by its own terms, then as addressing when and only when the court can address these claims, then that would be the limit. There's no judgments of acquittal after that. That's not what the people are arguing. The people are arguing that the rules should be read together with all of the rules, 51 and 52, which do address when an issue is preserved and the standard that applies to preserved and non-preserved claims. And then when reading them together, there's a preservation requirement, a specific preservation requirement, and that when it's unpreserved, then you get plain error review.
So here we do have a motion for judgment of acquittal, and help me understand why, having raised the issue of the sufficiency of the evidence, that motion is insufficient to preserve this claim on appeal.
Yeah, and it goes back to the reasons for the rules, reason for the objection rule, and the language of the rule in CRIM P51, which says in the grounds therefore, and that's that in these situations where you're arguing that there is something beyond the obvious requirements of the statute, something outside of an ordinary reading of them, that the general objection just does not place the trial court or the parties on notice that that is being raised. And so in Martinez, it discusses a lot of those reasons why a general objection is generally not sufficient, except for those things that are obviously brought into play. If you're arguing something outside of that, then you need to have more than a general objection. So we're arguing that those holdings that this court already has regarding requiring specific objections are well-reasoned and should be maintained.
So let me press you on that for just a moment, because I'm trying to discern if you're drawing a distinction between a sufficiency claim that's based on the quantum of evidence presented as opposed to a sufficiency claim based generally on the interpretation of the criminal statute. Mm-hmm. Or are you further refining that to say, no, it can't preserve a non-obvious interpretation of that statute?
I think the latter, a non-obvious interpretation of that statute.
And so a motion for judgment of acquittal, just a generic motion for judgment of acquittal that ostensibly is based on the quantum of evidence at trial, doesn't raise any question of statutory interpretation. If on appeal, it's a very straightforward, based on the plain language of the statute, that is sufficiently preserved by the general motion of acquittal? Where do we draw this line?
Yeah, what this court has said regarding general objections, in general, is that if it's obvious from the context, then that's sufficient. So I think if you made a general motion for judgment of acquittal and then you're just arguing a straightforward claim that one of the clearly obvious elements of the crime is not committed, that would be sufficient to preserve that.
But let me ask you this then. Generally, questions of statutory interpretation are questions of law. Generally, we review such questions of law de novo. And so when it's a question of statutory interpretation, I guess I'm struggling to understand why it is so necessary that that question of statutory interpretation be flagged for the trial court. If on appellate review, a reviewing court's going to look at that de novo anyway.
And it's because of the consequences of whatever that interpretation might be and the need to develop further facts based on that interpretation and the ability to develop further facts based on that interpretation, if that makes sense. So if the defendant is arguing, hey, there's this thing that they didn't prove, this non-obvious requirement, and if the court agrees, then it can say, okay, prosecution, can you prove that? Or it can say, I don't think you have to prove that, but the prosecution can say, we'd like to present our evidence on it anyways in case the Court of Appeals or the appellate courts disagree, and the court could permit them to do that.
And given the structure of Rule 29, though, the fact that that motion could be made after the close of evidence, I guess I struggle to see why that's important.
Sure, I will. I'm glad this came up because I like to address this because that's kind of the argument raised in the reply brief about the reservation language in the rule. And I'd first like to say it has long been the settled law in Colorado that the court can reopen the case in response to a motion for a judgment of acquittal. We have a holding of the Court of Appeals and Waters that's been around for a long time that says you can do that. And the defendant's argument regarding the reservation language in Crimpy 29 does not require overruling that law. I note that this was the argument that was rejected by the Massachusetts Supreme Court in the case that I cited in my answer brief, which was Commonwealth versus Hurley, 913 Northeast 2nd, 850. They were specifically addressing this argument that reservation language means that you can't reopen the case because you have to rule on the judgment of acquittal before reopening the case. And in context, the language from Crimpy 29, especially when you contrast it with the language in the federal rule that it deviates from, was intended to prohibit the court from reserving ruling until after the defendant presents a case or a verdict is reached by the jury. It wasn't intended to dictate the order in which the trial rules on pending motions after the prosecution initially rests. But I'd also argue, even if it was, if the people represent in response to the defendant's motion for judgment of acquittal that they have evidence on that issue that they could present, the appropriate ruling for the trial court would be to deny the motion for acquittal as premature and then grant the people's request to reopen the case. And I did analogize this to, it's just how an appellate court, when reviewing the evidence, considers all of the evidence presented at trial, not just the evidence that was presented at the initial motion for judgment of acquittal was made. And the reasoning for that has always been that we should focus on achieving a just outcome. And this is allowing the prosecution to reopen the case when in this situation is what would promote just outcomes. So be my response to that. And definitely, if you're concerned about that, look at that Hurley case and their explanation for why that is not a compelled reading of that rule language.
Can I ask you a question about Rule 51, Mr. Swanson? You've kind of focused on that about having to make an objection. I mean, I know Rule 51 talks about ruling or order of the court. Does that apply to a verdict or judgment? I mean, it strikes me as a ruling of the court is arguably different. And of course, Rule 51 was principally just get rid of the necessity of an exception, which used to be required. So is a ruling or order of the court different from a verdict or judgment?
Well, when we're reviewing these, how the courts have described this is we're reviewing the court's decision to give it to the jury, not the actual verdict. That's what an insufficiency of the evidence claim is. And also that I would note that exceptions were required for insufficiency of the evidence claims prior, so that would implicate the rule. So I see I'm out of time. I ask the court to affirm the judgment of conviction. Thanks.
You.
I think in regard to the notice question about notice to the prosecutor for what is required by the statute. Again, they're the ones who charged the defendant and chose what statute to charge them under. There's no hidden surprise in these statutes. It's just a plain language argument. For example, in the burglary statute, it requires one of the elements is intent to commit therein a crime against a person or property. And that's all Mr. Maestas was arguing, is that he didn't do that for Poindexter and just based on the plain language of the statute. So I fail to see how the state did not have sufficient notice of the requirements of what it needed to prove. And again, were there any question about that, I don't see how that would also provide notice to a defendant constitutionally of what conduct constitutes a crime. And that's United States v. Harris is the Supreme Court case, and Bowie v. City of Columbia.
Is it your view that by hiding in the garage, that by itself, that's obstruction of the police officer, inherently cannot be a crime against a person, or simply that because he was hiding in the garage and there's no evidence that he used force against the officer when the officer tried to arrest him, that for that reason, the evidence is insufficient?
I think both, again, and not to not take a position, but I think that certainly under the facts of the case, so certainly the latter, just hiding in a garage is not enough. It's not intent to commit therein a crime against a person or property. But then also obstruction of justice is a crime against government offenses. It's not in Article 3 or Article 4 of Title 18. So it just doesn't really make sense. There could be a situation where, because you can remain unlawfully with intent to commit therein a crime, where a circumstance arises where maybe, there is force used, but that would potentially then be burglary with a predicate of assault against a peace officer or something like that. So I don't know that this court needs to take a categorical approach. Poindexter took a case-by-case approach, which I think is perfectly fine, but I think it could also be certainly not the categorical. If this court were to apply plain error to sufficiency claims, it would be contrary to historically what Colorado courts have done up until Lacalo. But if it does, the Henderson approach certainly has the benefit of avoiding the due process issue, applying the error at the time of, that's obvious at the time of appeal. And again, like Justice Gabriel articulated, once a court interprets a statute, it's just explaining what that statute always meant.
Could I ask a question about Henderson real quick? If we were to adopt the Henderson approach with regard to the obviousness, would we then feel obliged to reconsider whether to also adopt the fourth prong in the federal 52B cases?
I mean, I think it creates a sticky situation for this court. The Henderson question is before this court in another case later this term, I believe, People v. Garcia. And, I think that in general, adopting plain error review to sufficiency claims has not been done in Colorado by this court. It creates a lot of problems. The federal circuits are not uniform about how they apply plain error to sufficiency. Our Rule 29 is different. There are a lot of reasons to avoid a federal approach. If this court is interested in the Henderson question, it does get to look at it more on point in a later case. I think this is generally not the case to adopt plain error in.
Okay.
Thank you very much.
Thank you. Well, we appreciate the arguments of both counsel. The case will stand submitted, and we're going to take a 15-minute recess. I'm informed that we have some high school students from Fort Lupton with us. I appreciate you being here. Next argument we have on our calendar is styled McCoy v. People, set for an hour. Both counsel look situated. Counsel for the petitioner, please begin your argument when you're ready.
Good morning. May it please the court. I'm John Grevelius, and I represent David McCoy. Your Honors, this morning I plan to start with the merits issues presented in the briefing and maybe circle back if there's time to more of the preservation arguments that were addressed before me. Certainly if this court has questions on anything, I'll take those questions as they come. Today, Your Honors, what I'm asking this court to do is to apply its decision in People v. Terry to the unlawful sexual contact statute. People v. Terry addressed the identical language we're going to deal with today that appeared in the companion sexual assault statute, the second-degree sexual assault statute. That language that Terry addressed was adopted at the same time as the language we're talking about today and by the same General Assembly. So when I'm talking about the same language, I'm talking about the treatment or examination of the victim language. And this court in Terry concluded that that language was intended to target only those in a position of trust by dint of their professional status from taking sexual advantage of their patients. This court's interpretation of that language is supported by a reasonable reading of the statute as a whole and companion statutes in Part 4 of Article 3 in the Criminal Code, as well as other canons of statutory interpretation, including constitutional avoidance and legislative history. Now, contrary to the Court of Appeals decision below, the prosecution must show that there was either a medical provider-patient relationship that was abused or a fake medical patient-provider relationship that was abused on an unsuspecting patient during a medical-like exam. Now, in Terry, this court used the language medical practices in the statute, which the state and the Court of Appeals implies only codifies a defense to the statute, to hold that a chiropractor is subject to the prohibitions in this statute because a chiropractor offers medical services to patients. So in its thorough analysis, I do not believe that Terry is distinguishable and must be applied in this case. Another important aspect of Terry that bears mention is that this court rejected Mr. Terry's overbreadth argument. As this court recognized, when it resolves an overbreadth argument, it has to determine whether the statute prescribes any constitutionally protected conduct. And this court reasoned that Mr. Terry's claim failed because medical providers have no constitutional right to have sexual relationships with their patients. But looking at the statute as well, and in support of the Terry decision, we see that what we're really dealing with here is an abuse of a very specific position of authority, and that's the medical provider as a professional relationship with a patient. When this medical fraud provision was added to the Criminal Code in 1975, it was included among two other provisions that also specifically target those in a specific position of trust with respect to the victim. Subsection E, which has since been removed and placed elsewhere in the Criminal Code, dealt with parents and guardians in a position of trust over the child victim. Subsection F similarly dealt with abuse of a relationship between law enforcement and an inmate in a detention facility or a hospital. And so too was subsection G, with what we're dealing with today, the doctor-patient privilege and the doctor-patient relationship being abused. Further, Your Honors, it's important to note that unlike any other provision in the unlawful sexual contact statute, violation of subsection G is a class 4 felony, not a misdemeanor. And it's so precisely because the legislature is targeting a very specific form of conduct in a very specific context. Notably, other professionals who abuse their positions of authority over a victim and take sexual advantage of them, like law enforcement and hospital staff, or psychologists who use therapeutic deception to accomplish sexual contact on patients are only subject to misdemeanors. So through a sensible reading of the statute, Your Honors, we see that the Court of Appeals erred in basically concluding that it applied broadly beyond the medical context. It's also my position, Your Honors, for what it's worth at this point, that not only does a sensible reading of the statute support my view, but the legislative history, which the state and I quote at length and discuss at length, supports my reading of the statute. Now, as to the specific merits here of my claim, I want to start by addressing generally the facts as it applied to both PK and GM, and then I'll move to each specific count 1 and 2. But Mr. McCoy submitted neither PK nor GM to a medical examination as a treatment provider.
Well, Mr. Gavelli, so why don't we at least have a fake examination? I mean, he told them both he was a doctor or a pediatrician or he studied, and we need to do this examination for purposes of this job. Why doesn't that satisfy just the plain language?
Sure, Your Honor. Well, there's certainly a dispute about what my client allegedly told each one, and I'll get to that in a moment. But sort of looking at the totality of the circuit, looking at all of the evidence as a whole, which this court must do, we see that, one, he represented to both on the front end that he worked in the television industry. He invited them both to his apartment to come work for him and train for him in the television industry. These alleged incidents occurred late at night in his apartment and on his bed. So, as a general matter there, that's the sort of the background that I want to set this up in. As to PK specifically, it is true that PK did testify, that on direct, my client represented that he was, quote, a physician. Now, what my client actually said to PK is a little unclear because PK also testified that my client only once represented having some sort of medical background or training, and he told the police that what my client told him was that my client went to Harvard to study psychology. However, that's not the only reason I'm pushing a sufficiency claim here. Two other circumstances are relevant here, and that's one, when PK was asked by the prosecution whether he believed that my client was a medical provider or providing medical examination, he did not say yes. What he said was he submitted because he was told this was a trust exercise and that he didn't want to upset my client. I think this shows that PK knew this was not a fake medical exam, but that it was something else. Further, PK admitted that after he was massaged by my client, he in turn gave my client a massage. So under the circumstances here, PK was not subject to a fake medical exam. As to GM explicitly stated that my client did not represent being a medical professional or provider during the alleged incident. GM said that this was merely implied. Like PK, what my client allegedly told GM is unclear. GM testified that my client represented that he was a pediatrician, but GM also told police that what my client said was that he went to Harvard to study to be a pediatrician, then moved to psychology, then law. I don't know exactly what my client allegedly told him. As before, this occurred late at night and on my client's bed, and after taking GM's pulse, my client told GM, according to testimony from police, that he needed to see a doctor, which suggests that my client is representing to GM that he is not a doctor or a medical provider.
Mr. Gravelius, did I say your name correctly?
You did.
Okay, thank you. It feels like you're asking us to reweigh the evidence. I mean, am I missing that?
No, Your Honor. I appreciate that this court does not decide credibility issues. It does not reweigh the evidence. All I am saying is that under the circumstances of all of the evidence which must be considered, no rational trier of fact can conclude beyond a reasonable doubt that my client abused a medical privilege here.
All right.
You mentioned, Mr. Gavilius, legislative history. I'd like you to focus in on that, if you would. So 183402, the sexual assault statute, they added language about, I don't have it right in front of me, but under the guise of being a doctor. You're essentially asking us to read that language into 404 when the legislature didn't put it there. Could you just address the legislative history for us?
Yes, of course, Your Honor. That language that was added to 402 came as part of a lengthy omnibus bill. And what had happened is, and I believe it was the Senate Judiciary Committee debates, One senator had mentioned that the medical provision, the identical medical provision appearing in 402, appeared to be too broad on its face, and he had mentioned several examples of people playing doctor who might get caught up in this. And so there was a lengthy debate in the committee about this, and notably, several district attorneys were present, like Mitch Morrissey and I can't remember the other gentleman's name, but they discussed that how the statute had always been understood to apply to the medical context and only been used that way. But nonetheless, the senators present there added this to the bill just as a means of clarifying. They made it clear that they were not changing the scope of the statute in any way. They were merely just clarifying what they intended. Now, why this doesn't appear in 404, our statute, is never really made clear to me. They never discussed the identical language appearing in 404. I mean, frankly, it appears almost as though it's oversight. And I know that's sometimes a little bit difficult of to believe, that we would presume that, but that really is what it appears. But further, if the legislature is only intending to clarify subsection 402, that means it's not changing its meaning. That means the Terry interpretation of it is still right and still should even apply here because it is not changing the scope of the statute. Not changing what it means, it's just clarifying what it means.
So, if I may, why isn't the answer then to say that the 402 language, while purporting to offer a medical service, should also apply under 404, maybe to avoid vagueness problems, rather than relying on Terry? Isn't an alternative solution to adopt the reasoning that you just advanced to say that that language should also apply with respect to unlawful sexual contact as well?
As a means of avoiding unconstitutional results? Is that what I understand?
With respect to vagueness, I don't think
Yes.
the overbreadth argument goes anywhere because of Graves, but putting that to one side, just on the vagueness front.
Well, certainly, yes, Your Honors. As we interpret statutes, we avoid unconstitutional results. And as I've briefed, in order to avoid a vagueness problem, it does need to be at least narrowed or somehow specified what type of treatment or examination we're talking about.
So tell me more specifically your understanding of what the legislative history really shows us with respect to whether or not this was just an oversight. I was a little confused by it reading the briefs because it seems that, as best I can understand, there was some discussion about 402. I don't think it was Morrissey, at least according to the People's brief. I recall it being Grant and Ritter.
Oh, you're correct. I'm sorry.
So, but I gather that they were talking specifically about 402, and as I understand it, Ms. Allen will disabuse me if I'm getting this wrong, but she seems to be extrapolating a little bit from the conversation about 402 to say that it was never meant to encompass non-consensual stuff under the unlawful sexual contact statute as well. But I wasn't entirely clear whether there's any legislative history that tells us specifically what they were intending to do with the statute that's at issue in this case.
Well, Your Honor, as I alluded to, it's not clear. That statute, Section 404, was never mentioned when they were discussing 402 and the language they're adding to it. It just simply wasn't brought up. And the reason why I had mentioned that maybe oversight was a cause is because this was an omnibus criminal bill. I think the bill was over 50 pages in length, and it amended, I can't even tell you how many statutes in the criminal code. There was just a lot of moving parts. So there was nothing actually said about 404.
Okay. Well, let me just follow up, if I may, then. Hypothetically, if we were to take the language from 402 and apply it under 404, say to avoid a vagueness problem, what does that mean for your client?
Well, it would still, as I've said before, the language that appears in 402 doesn't change the statute. It just clarifies it.
Okay.
So my position is it still requires a fake medical exam.
Right.
And that even with the reading that we would have under 402, it still would not be a sufficient, we do not have a fake medical exam, is still my position. It doesn't change my argument, in other words.
Okay, all right.
That makes sense.
Thank you.
Oh, I'm sorry.
Okay, I was trying to decide whether to ask or not. Are there some parts of the exam that could classify as fake medical exams? I think if I was reading the testimony correctly, at one point when when your client was very close to one of the victim's private parts. It's very weird talking about this with kids in the audience. It was in that context that he said he was a doctor and this was necessary. Am I misremembering that?
Well, I don't believe he said it was necessary in the context when he said it was a doctor. I think he said, at least according to PK, I think that's who you're referring to. PK testified that my client said he was a physician and don't worry. Granted, I do appreciate that that's the testimony. However, under the circumstances and according to PK, he said he didn't believe that this was a medical exam, after the fact. And so I just wanted to touch upon briefly, Justice Hood, your point about overbreadth. Certainly, I think this case can be resolved under vagueness principles and just common sense reading of the statute. So I don't want to go into it too much. But I did read Graves, this court's opinion in Graves, to at least leave open the possibility that we could have a fundamental protected right within the privacy of our own home for consensual sexual contact, and that might pose overbreadth problems. Again, I think that we can resolve this on vagueness. I think that's probably the stronger point. But nonetheless, it's my position that it would probably be overbroad, at least if it does prescribe the activities that I have alluded to in the briefs. Your Honors, with the time I have left, I want to circle back to the preservation issues, and I don't have much to add to that. And certainly if this court has questions on the prior topics, I'll stick to that. But I wanted to touch on one argument that the state made in the last argument about notice to the prosecution. And it was important, the argument was that it's important to notify the prosecution below so that they could reopen proceedings and actually prove the case under the correct statement of the law. I respectfully disagree with the underlying premise that the prosecution is entitled to reopen evidence under a misunderstanding, of the law. It's true, cases like Walters, which was cited in the state's brief in this case, have carved narrow exceptions to Rule 29 to allow prosecutors to reopen evidence. But in that case, notably, the evidence that was allowed to be presented was one of venue. There was testimony that the crime occurred, I think it was at like 88th and Sheridan, but no one had testified that that was Adams County. And so it was sort of a trivial or an exception because everyone agreed where the crime happened, and the prosecution could reopen evidence to just basically present that one minor uncontested fact, which was already in the record. And in this case, certainly all the cases that the state cites are similar in that they have reviewed cases where the court allowed the prosecution to reopen just to prove very minor uncontested things, not in cases where the prosecution has not understood the scope of the statute as determined by the legislature. Unless this court has further questions, I'd like to reserve the balance of my time.
Okay.
Good morning, Your Honors. My name is Melissa Allen, registration number 23155, and I'm here on behalf of the people. The statute at issue here, 18.3.404.1G, states that any actor who knowingly subjects a victim to any sexual contact commits unlawful sexual contact if the actor engages in treatment or examination of a victim for other than bona fide medical purposes or in a manner substantially inconsistent with reasonable medical practices. By its plain terms, the statute applies to any actor. It does not require that the actor be a medical professional or that there be, or purport to be one, or that there be a physician-patient relationship. Instead, what it requires is that the guise of a legitimate purpose be used to facilitate non-consensual sexual contact. The defendant's reading of the statute highlights the terms treatment and examination without considering them in the context of the rest of the statute as a whole. And those meanings, the meanings of those terms cannot be separated out from the broader framework of the statute, which is intended to prohibit all actors from duping victims into submitting to sexual contact by convincing them of the necessity of a physical examination or treatment, period.
Should for medical purposes be added to that? I mean,
I think we
The
already
guys
have medical in there twice.
right, but should under the guise of a legitimate purpose to induce the victim to submit to sexual contact, this was your description, a legitimate medical purpose for the examination? In other words, is the purpose of this exam, is it relevant that the purpose of the exam is for, I need to make sure that you're sufficiently healthy, or I need to make sure that
Well, I
you
think-
can do this job?
I think that would fall under this statute because well, and again, here we're talking about someone who has put forth that they actually are a doctor. So, I mean, it's our position that no matter how the court reads the statute, the defendant's conduct in this case clearly falls underneath it. And
Because it was for ostensibly medical reasons, the exam?
because he testified, I'm sorry, he didn't, because the victims testified that he represented himself as a doctor, and that was part of the reason that they trusted, that they allowed themselves to be examined by him. It was also because they felt like they had to in order to get the job. But I think it's a combination of those two things. And I think that it's misreading the statute to require this, doctor-patient relationship, and that they believe they're undergoing this like true medical exam, because I don't think that the statute requires that. I mean, there are a lot of things that could fall under this statute. You could have, for instance, a gymnastics coach who has worked with gymnasts for years, and by dint of their professional status, these people trust their coach, and he says, "Oh, you've got a pulled groin muscle. I know exactly what to do." And they allow themselves to be treated and examined by this person, and if it's done for other than bona fide medical purposes, I think that person would have violated this statute.
So, Ms. Allen, I hesitate to take you away from the plain language argument, but obviously, based on my other questions, I'm kind of anxious to get to the legislative history
Sure.
piece. I guess if we accept the notion, or at least for the purpose of my question, that there's some ambiguity here as to what exactly the statute means, and that it's reasonably susceptible to different interpretations, then what do we know about 404 based on the legislative history from the 2000 revisions? You heard me sort of summarize what I understood you to be arguing in your brief. Did I get it right, or did I misunderstand?
Well, there are two sets of legislative histories that I went through in my brief. And the first was the 1975 legislative history, when they redrafted everything because we had the first degree sex assault, second degree, and third degree, and then they wanted to combine it into just sexual assault. And it was in those hearings when they talked about the discussion turned to whether the goal was to just control doctors or to have the statute cover social workers, psychologists, pastoral counselors, faith healers, any of those. And the debate centered on the fact that if the language stated medical treatment or examination, then others in positions of authority who take advantage of individuals by virtue of that authority would not be covered. And that's exactly what I'm talking about here. So in the end, they removed medical from before treatment and examination to cover everybody. And that's from pages 28 and 29 of my brief. It's such a long cite for the hearings, but the cites are all in there. And I footnoted at footnote 4, they keep talking, well, when you say the actor engages in medical treatment or examinations, you've got doctors, and then someone else says, don't you remember? That's what I was asking you about. So when this statute went on the books in 1975 or after the revisions, that was the discussion, that it was meant to cover a vast majority of people who, because of their authority or because of the way they represented themselves to people, they could examine or treat them, and it still has that medical feel to it because of the rest of the language in the statute, but it doesn't mean it has to be a doctor, and I think that that's, at least for the plain reading of the statute, I think that that's what an important takeaway is. And then, to get to your other question, in 2000, they revised it, and it was, actually, I apologize, by the way. In 2000, the 2000 revision was when they put everything into one sexual assault statute. So in 1975 is just when they put the statute out there. And even though the language was exactly the same, and they were just combining it into this one statute, Representative Mitchell and another representative kept voicing their concern, and their concern really covered the idea that they were afraid that consensual relationships were covered by this statute, and that they thought that while purporting to offer a medical service would clear that up. And that's what Bill Ritter talked about. He kept saying, this statute's been on the books for 25 years. It already has that language in it that consensual activity would not be covered.
But that's the issue. They try to fix that in 402, but the problem is that the language isn't in 404. I mean, if you read the language literally of 404(1)G, actor engages in treatment or exam, et cetera, for other than bona fide medical purposes, that literally would cover a consensual relationship where a couple is playing doctor. So I think what you're saying is you have to read in for the language or whatever to the language that says bona fide medical purposes does suggest someone purporting to provide this picks up on Justice Marcus's question, providing treatment or an exam, whether you're an actual doctor or not. I mean, I think what you're saying is we need to read that language in, and if you're not saying that, I guess my question is, don't we have to read that in to avoid a vagueness problem?
Well, I think the language is already in there, and I think that Terry says that the language is already in there because Terry covered this exact language before the revision.
But the focus on Terry was you don't have to be a medical doctor. Chiropractor is enough. I'm not sure,
But it did.
Okay.
You're right. But it also said that bona fide medical purposes means when it is not taken in good faith, honestly and sincerely, in the course of investigating, preventing, alleviating, or curing a disease or malady. I mean, I think that discussion of what that means covers non-consensual contact. Consensual contact would not be covered under this.
Well, why? I mean, and I'm playing devil's advocate with you because I'm just trying to figure out how we would write the rule you're asking us to write. If you read this literally, a husband and wife engaging, playing doctor in a, sexual relationship, I'm going to examine you now, dear. That's not for bona fide medical purposes. That's an exam. That's sexual contact. That literally covers this. There's no language in here about non-consent. So it seems to me, I ask you to push back, that this is arguably ambiguous, and I think we may have to read in the language you're suggesting, but I'm not seeing why it's there.
Well, my opinion is that Terry covers this and says by virtue of the language in Terry, we know that this doesn't cover consensual contact, but I understand the court doesn't agree with me. I would
Well, I'm
also-
not, I don't, I'm just asking. I just don't, the word, it would be nice if it said non-consensual in here, but it doesn't.
Well, we do have a definition of consent in 18.3.401 1.5, which is defines everything under this statute. And it means an exercise of free will and with knowledge of the nature of the act.
I agree with that, but the word consent doesn't appear, or non-consent doesn't appear in 18.3.404.
G.
Does, in
It
G.
does appear in other parts, which I think
Yeah,
is,
right, that's what I'm asking. It's not in G. Thank you.
But the statute as a whole does talk about bona fide medical purposes or so I guess I'm not understanding. You're saying that the additional language of while purporting to offer a medical service, I read that, I guess I read that in there. I do, because we're already talking about for other than bona fide medical purposes or in a manner substantially inconsistent with reasonable medical practices.
So you're suggesting that, and I'm just trying to clarify, we need to read in that it's really the actor, while purporting to provide a medical service or treatment, does an exam or treatment for other than bona fide treatment purposes.
Yes.
Okay.
I mean, and I think that it's already there, and I think that that's what the district attorneys were saying when they were discussing the legislative history, and it was like this, I mean, you could tell listening to the tapes that they were getting frustrated because they're like, it already does not cover consensual activity, but they were concerned and they said, well, we're not going to agree to it unless you put it in. So in the end, they put it in. But I would agree that,
I'm sorry. Yeah, but they did as to 402, but not as to 404. So it's sort of back to my question about the legislative history. I guess just to sort of button up what we were talking about before, am I correct in understanding that the Grant Ritter testimony was specifically about 402, and that when you then go on to make the argument about how that also encompasses 404, you're just kind of making an inference about how their discussion about it being non-consensual would encompass both statutes, right?
yes.
But is opposing counsel correct that we really just don't have any legislative history that's directly addresses 404?
Correct.
Okay.
Or at least in the hours that I listened to, I could not find it.
I'll bet that was a real treat,
It was
too.
really exciting.
Yeah. So the question, I guess just to reiterate what you just told Justice Gabriel, is the Terry language in your mind's eye sort of equates to the while purporting to offer a medical service language anyway, and so if we decided that we just wanted to import that into 404 to offset any, or to address any vagueness concerns, that would be okay with you?
Yes.
All right.
And I wanted to talk briefly, I think it's important to note what the Court of Appeals discussed below. And I read, I think that the court it didn't look at any legislative history. And so it just simply said, 402 has this additional language, 404 doesn't. But the court was directly responding to the defendant's arguments in the Court of Appeal as to what they were saying the statute meant. And I just wanted to briefly let the court know what that was. They argued that in order to satisfy the statute, the prosecution had to prove that the defendant was or purported to be a medical professional, that the sexual contact occurred during the course of a real or purported medical treatment or examination, that the alleged victim submitted to the sexual contact because they thought the defendant was a doctor engaged in legitimate medical treatment or examination, and that it was done for other than bona fide medical purposes or in a manner substantially inconsistent with reasonable medical practices, which is a mouthful. I read that argument as, unless you are in a situation where you're in like a doctor's office and you're truly undergoing some sort of physical examination, you can't satisfy this statute. And I think that that's what the court was saying when it said, It doesn't have to be this real medical examination. I don't think it was saying, anything other than that. It was just, it was taking it out of the idea that it has to be the type of situation where someone goes into a doctor's office or a chiropractor's office or anything like that. I mean, I think what's covered under this statute, still with the idea of this medical, purporting to offer medical service, is anyone who says, I studied that. I'm studying to be a masseuse. I know how to fix that pain in your, fill in the blank.
If it constitutes some kind of medical service, purportedly.
Purported.
Right, so can you address opposing counsel's argument that even if we were to import that language to 404, his client still wins because of the record that he recited?
Well, I think that there are two problems with that. It's almost as if his argument is asking this court to reweigh the evidence that was presented at trial. And taking the evidence in the light most favorable to the prosecution, he purported to be a physician. And I don't think the statute, that there's any rule in the statute that says they have, he has to purport to be a physician and they have to absolutely be undergoing this exam only because they believe he's a physician and all of that type of thing. I think the fact that he used that as part of his ruse to get them to consent to the physical contact is enough. And specifically, this is what I have from the record on what the two victims testified to. PK testified that when he expressed concern about the defendant's examination, defendant, quote, assured him that he's a physician and not to worry, PK needs to trust him. He also testified that, let me know if you want transcript cites, by the way, for any of these.
I think these are in the brief.
In the brief, yeah.
Yeah, go ahead.
PK further testified that defendant, quote, told me that he was a physician and he's done this 1,000,000 times and that, I didn't need to worry about anything. It's just routine. It's like regular. I haven't gotten a physical in a while or been to a physician in a while, so I didn't really know. I didn't know what to think or say, even though I felt really uncomfortable. So it's clear that that was part of why he was submitting to this examination. GM testified that soon after their meeting, the defendant informed him that he got a degree as a pediatrician and knew what he was doing. He told him he'd worked with many people's bodies and it didn't mean anything to him because he had seen so many people and it was just like part of the job. GM also testified that he submitted to the defendant because the defendant stated that he was concerned about GM's health, which made him concerned about his own health, so he agreed to the examination. So overall, he told these people he was a physician or he'd studied medicine, he had a medical degree, he knew what he was doing, they needed to trust him and trust him as far as knowing what he was doing and examining them. In the meantime, what he was doing was trying to have sexual contact with them.
So, I'm sorry, go ahead.
Given that description of the evidence and thinking about the structure of 4041 and all of its subsections, right? So we have 1G, which is the provision at issue here. But the others refer to lack of consent, right? So actor knows the victim doesn't consent. Actor knows the victim is incapable of appraising the nature of the victim's conduct. Physically helpless, unable to consent. It seems like all of those 4041 provisions are talking about situations that are non-consensual and not the example that Justice Gabriel was suggesting about in the privacy of a marital home, okay? But one of the questions that's come up is, well, why doesn't G actually state the word consent? And I'm wondering if that's because arguably the victims did submit to the contact But they were duped into doing so.
That's exactly right. And you can't consent when you don't know what you've consented
Consented to, which ties you back to the definition of consent. Okay, thank you.
And I briefly wanted to, I mean, obviously, these are all of these arguments are tied together because the way you read the statute deals with, we have to talk about overbreadth and vagueness as well. And, you know, I think that the way the statute reads, it clearly does not cover consensual conduct. So it's not bringing under the ambit of the statute some of these sexual relationships that we were talking about in the brief between two consenting adults. There's no, in the playing doctor scenario, there's no duping. You've got two willing participants who know what they're doing, and that's the end of the inquiry. And as far as vagueness, I think that because his conduct is so clearly prescribed by the statute, that's as far as we have to look. I don't think there's any question that what he did is covered by this statute.
Well, can we talk about that? I mean, I think there are some specific instances during the time that he spent with the victims where, as I said in questioning Mr. Gravilius, it seems like they might have thought it was a medical exam or thought he was, again, not that he was a doctor, but that he had some sort of training that would enable him to do an exam of that sort. But what about the nights in bed kind of things? There's an awful lot of conduct that doesn't seem like anyone could reasonably have thought it was a medical or an examination.
Right, and I don't disagree, but if I remember the evidence correctly, it was the touchings that occurred during the guise of these examinations that were the basis of the charges, as opposed to, possible other contact. And to the extent there was other contact, that was the misdemeanor charges that simply, I believe it's 1A that just says, and the actor or the victim doesn't consent.
Okay.
I think that's what was covered by those. I don't think I have anything further unless this court has any other questions for me. I would ask that the court affirm the Court of Appeals. Thank you.
Thank you. All right, case will stand submitted. We thank both counsel for your arguments. And the court will be in recess until 1:30.